So good afternoon, everyone. Welcome to today's webinar, which is Immigration Law Review of the Year webinar, Key Cases and Rule Changes from 2023. Our speaker today is Adam Pipe, barrister from No. 8 Chambers. For those of you who haven't joined one of our webinars before, my name is Aaron and I'm an assistant consultant at DG Legal. The slides from today's presentation will be sent over to you tomorrow, and a recording of this webinar will be available for 3 months following this webinar. So if we do run over and you need to leave, you'll be able to watch the rest at another time. We are in webinar mode, so that means we can't see or hear any of you on the screen. So please use the Q&A function, the chat function, as you already have been if you do wish to communicate anything, although we do not think we'll have time to conduct a Q&A in this webinar today. As I previously mentioned, our speaker today is Adam Pipe, and he is a barrister specialising in immigration, asylum and human rights law. He is ranked by Chambers and Partners for immigration law in the Midlands, and Adam provides regular updates on the law at training events and on social media. And with that said, I would now like to hand over to the man himself.
Brilliant. Thanks, Aaron. That's so good. Let me just share my screen. Hopefully everybody be able to see that. Yep, that's there. So as Aaron said, the slides will be available and the webinar recording will be on YouTube, because this is going to be a fast moving update looking at the latest changes from 2023. We're going to start by looking at the changes to the immigration rules. Then we're going to look at a case law update. So happy new year to everybody. Thank you so much for joining us. I think about over 1,000 people registered for this webinar today, which is just amazing. Thank you for those particularly who've joined from overseas. And thank you to DG Legal for, again, providing this amazing resource to the legal community. Thanks to Aaron and Robin, who are supporting on Zoom today. As I said, we're going to go through things quite quickly today. So I do encourage you to go back over the slides, use the slides. You can cut and paste from them for your skeleton arguments, your representations, your pre-action protocol letters. If you'd like a more in-depth look at this stuff, do sign up to one of my longer seminars where we'll have chance through a morning to go through this stuff in more detail. And as a bonus for you who have logged on early today, just some news that's hot off the press. Last night, Parliament approved the Immigration Health Charge Amendment Order 2023. I don't want to send everybody into panic, because they've now approved that order. There's 21 days from approval. Until then, the new immigration health surcharge comes into force. But I get lots of questions most days about the immigration health surcharge. The order was approved in Parliament last night. So there's a bit about me and a link to Chambers for anybody who needs it. But as usual, I put my QR code on the screen. So now's the time to get your phones out for a bit of a free gift. I try and update that link all the time with my latest videos, my latest free PDFs, any resources, any speaking events. So scan that QR code. There's also a link to sign up to a free Telegram channel on which I post all of my updates, and you can sign up to the YouTube channel as well. If you're old school and you prefer a link than a QR code, the link is there, and I'll come back to this at the end, but do sign up for those. And I'll let you know when I've done a video on a particular case if you want to go back and spend some time looking at it. So let's start by looking at the changes to the immigration rules. And we're going to look at some of the key statement of changes from 2023. The first one was the big spring statement of changes from the 9th of March 2023. It was all 185 pages of changes. I put some helpful insights from a couple of solicitors' firms and some links there, and a link to the explanatory memorandum. One of the first things was the introduction of the new innovator founder route and the closure of the startup route from the 13th of April last year. So the innovator route, and now the innovator founder route, is about establishing a business that's innovative, viable and scalable, and it must be supported by an endorsing body, and an applicant must have a key role in the day-to-day management and development of the business, and it is a route to settlement. Now, what the innovator founder route did was remove the £50,000 minimum fund requirement for those coming to the UK. So there's no longer, with the new route, the £50,000 minimum fund requirement. There was also a relaxation allowing innovator founders to work outside their business as long as it was at the appropriate skill level. With the removal of the 50,000 minimum funds, there is no longer a need for a separate startup route. So the government have closed the startup route. This is important. Long residence changes. So from the 13th of April 2023, the definition of lawful residence to count towards the 10-year long residence rule was amended, and time spent on immigration bail or as a visitor or as a short-term student or a seasonal worker could not count towards 10 years lawful residence. So you may have clients who think they can qualify for 10 years, but don't as a result of these changes. Now, the Home Office messed up with this statement of changes because what they did was only exclude the current versions. They only excluded immigration bail, but they made no reference to temporary admission, which predated immigration bail. They referred to Appendix V, but didn't refer to the predecessor rules or the predecessor short-term student or the predecessor seasonal worker routes. So there's another change that came later in the year to include those. So technically there are people who may qualify under the long residence rule even after the changes of the 13th of April, as long as they got the 10 years before those old predecessor rules and routes were ruled out. And I've had to certainly lodge a JR in respect to that for somebody who was relying on leave as a visitor that wasn't under Appendix V, but was under the predecessor. So there may be these anomalies. And I know a solicitor, certainly, I don't know if he's on today, who had a client granted who was previously here as a short-term student and under the old provisions. There were also updates to the work routes in terms of the skilled worker, global mobility, scale up and the seasonal worker routes, an increase to the general salaries, thresholds and hourly rates, amendments to Appendix skilled occupation and clarification on how to assess salaries for irregular working patterns. Now, somewhat this has been overshadowed by the changes that are coming in spring 2024 to the salaries threshold. But here are the salary thresholds that were brought in by the spring statement of changes: the general salary threshold of 26,200, relevant PhD 23,580, or the PhD in a STEM subject 20,960, with the hourly rate across all categories of £10.75, and the minimum salaries for the scale up and also the senior or specialist worker were also clarified. There was also in the spring statement of changes an update and enhancement of the youth mobility scheme. There were additional places for both Australia and Canada. And as we'll see going through the year, as the UK entered into trade agreements, as we know, post-Brexit, there have been a number of trade agreements with various countries. For each of those countries, they get a trade agreement. They relax the youth mobility scheme. So this one is in relation to New Zealand. So again, New Zealand benefit from having the higher age limit under youth mobility up to 35 and the longer period of stay from 2 years to 3 years. The spring statement of changes also introduced the electronic travel authorization, and I've done a separate video on YouTube about electronic travel authorizations, which are for non-visa national travelers. So from the 15th of November 2023, it was required for Qatar. From the 22nd of February this year, 2024, the other Gulf states will come under this provision and need an electronic travel authorization, and the plan is to introduce it for all non-visa nationals by the end of 2024. One of the constant themes I'll come back to today is changes to the EU settlement scheme. All of us get headaches when we think about changes to the EU settlement scheme. These are some of the changes brought about by the spring statement of changes. The numbers are reference to the explanatory memorandum. One of them was the changes to the in relation to the durable partners. There was an unreported case previously where even the Home Office couldn't explain the meaning of the durable partner provision, but this clarified that if you had another lawful basis of stay before the end of the transition period, you didn't need documentation under the EEA regulations as a durable partner. There were some other clarifications as well in relation to Zambrano and Chen carers who entered as under an EUSS family permit. What we've also seen throughout 2023 as part of the simplification project is the introduction of various new appendices replacing old bits of the immigration rules. So this is Appendix Adult Dependent Relative, applies to applications from the 1st of June 2023, replaces the provisions in Appendix FM, and there are no real substantive changes, save for they did make a mistake when they originally introduced the appendix, and I'll come back to it later when I show what they clarified in relation to that. But what you will see, as we see with a number of new appendices, each one has its own Article 8 provision now. So in terms of adult dependent relatives, it's ADR 7.1, and it's helpful. It says, if the applicant does not meet all the suitability requirements or does not meet all of the eligibility requirements in AD 3.1 to ADR 6.4, but the decision maker is satisfied that the refusal of the application would breach Article 8 of the Human Rights Convention because it would result in unjustifiably harsh consequences for the applicant or their family. So that's important. Obviously, the ADR rules themselves focus on the care needs of the applicant in their home country. But the Article 8 provision focuses on the wider family as well. And it says there, the applicant will meet the Article 8 ECHR eligibility requirement. One of the things I wanted to say today is, for those of you who are representatives, you'll need to update your precedents, your representations, your templates, to make sure they refer to the new versions of the rule. So with an adult dependent relative, make sure you're referring to ADR. We all know that the adult dependent relative entry clearance requirements are very difficult. So you're going to need also to make representations on ADR 7.1 and the Article 8 impact, particularly on the applicant themselves or the family in the United Kingdom. Now, I'd encourage you, and I've talked about this in other seminars, if you're dealing with an adult dependent relative, make sure you've got good medical evidence. Maybe get a medic from the UK to interview over Zoom, or a social worker who can interview the whole family. Get good country evidence, maybe a country expert report. Show that there are no care provisions in that country. Maybe contact various care agencies or care homes and put evidence of the steps you've taken in your documentation. Maybe get country evidence as to how people are treated. So if you've got somebody with dementia who's a widow, how are people with dementia who have nobody else to care for them treated in that country? Because we need to make the adult dependent relative cases as strong as possible and make sure we're also arguing these human rights provisions. Now, I could spend the whole seminar looking at adult dependent relatives, but let's crack on. Now, in terms of deportation, they've also made clarifications to the deportation rules. They've not been taken out into a separate appendix, but they've now rewritten them within Part 13 of the immigration rules. So again, when you're making your representations in deportation cases, don't refer to 399 or 399A. You're now going to refer to 13.2.1, 13.2.2. And you'll see there, the private life exception is in 13.2.3. Then you have the family life exception in relation to partners or children in 13.2.4. And helpfully, this clarifies, If you're a medium offender who can't meet the exceptions, you still can succeed if you can show very compelling circumstances. If you're a serious offender, so a sentence for at least 4 years, you can only succeed if you show very compelling circumstances over and above. So there you are. I've set it out in the rules. Have a look. 13.2.3 is the private life exception. Then you've got 13.2.4, which sets out about a parental and a partner relationship, and then they're defined. And the outcome is set out then at part 3, and you'll be granted a period of not exceeding 30 months. Notice they've rewritten the revocation of deportation section. So no longer is there reference to passage of time like 10 years where there always has been in the revocation rules. They now reflect the deportation exceptions. So you've got to show the private life exception, the family life exception, the unduly harsh test, or the very compelling circumstances in order to get a deportation order revoked. Another new appendix is the family reunion provision. That applies from the 12th of April 2023. So now if you're making an application for refugee family reunion, you should be doing it under Appendix Family Reunion. And there's provision within there for adult children. So if you've got an adult child family reunion, go through the rules. There is also, similar to when I looked at the adult dependent relative appendix, there's also an Article 8 provision. So look at what it says in terms of Article 8, because you may have somebody who doesn't meet the eligibility requirements for family reunion, but you can argue it under the Article 8 provision. You've also got an introduction of an appendix child joining a non-parent relative protection. Again, these numbers are from the explanatory memorandum. These rules replace 319X to 319Y. Probably I can best explain this by way of an example. Say you've got a child in Zimbabwe who's lost both his parents. He's cared for by an aunt in the United Kingdom who's a refugee. He would be able to apply under Appendix Child, joining a non-parent relative protection. And the test, as I set out in italics at the bottom, is there are serious and compelling family or other considerations which make exclusion of the applicant undesirable. Now, I spent a whole DG webinar looking at children and entry clearance and the nature of that test. The key case is the case of Mandiba. The recording, I think, is still on the DG website. It's also on my YouTube. So do have a look at that webinar on children and entry clearance. But there is this new appendix child joining a non-parent relative protection. So that's the spring statement of changes. Let's fast forward now to the summer. 17th of July 2023, we've got HC 1496, which brought in, firstly, a positive change, which came in immediately, 3 p.m. on that day. And that was the end, I say end, the pausing, because they could bring it back in the future, of differentiating between Group 1 and Group 2 refugees. And as we know, Group 2 refugees only got 30 months on a 10-year route to settlement, and that would impact their family reunion and the like. That's ended now. And anybody who was granted as a Group 2 refugee should have been upgraded. If you come across somebody who hasn't, you'll need to make representations, because there is no longer a differentiation between Group 1 and Group 2 refugees. So let's start on a positive note with the summer changes. Now, let's move to a worrying note. What the Secretary of State has done in these changes is expanded the basis upon which he can treat an asylum case as implicitly withdrawn. What I've done on the slide is put on the actual amended version of Immigration Rule 333C. A deals with explicit withdrawal, B deals with implicit withdrawal, and sets out 5 Roman numerals there, 5 different scenarios where the Secretary of State can treat an asylum claim as implicitly withdrawn. The problem was they didn't amend this until it wasn't in effect from the 7th of August. But even before that date, the Secretary of State was treating claims as implicitly withdrawn when she didn't have, or he didn't have the power under the immigration rules as they then were. He'd amended their policy, but the rules themselves didn't change till the 7th of August. There's a really helpful briefing on free movement. Sonia's put that on free movement. I've certainly had to do JR grounds where they've treated something as withdrawn implicitly before the changes of the 7th of August, and relying on the old Supreme Court case of Alvey, where requirements must be in the immigration rules, they can't be in policy. But just be aware of that. And when we saw the statistics for asylum decisions coming out, and the government claiming they'd cleared the backlog, what we noticed was a huge increase in withdrawn decisions. So the Home Office are using this and treating things as withdrawn. So something to be aware of. Probably the big news on the 17th of July that caused me the most text and emails and telephone calls was the changes to the student route and the consequential changes to work routes, which again came into force on 3 p.m. on that day. And it removed the right for students to bring dependents unless they're on postgraduate courses currently designated as research programs. It also removed the ability for international students to switch out of the student route into work routes before their studies had been completed. There was transitional provisions for those already here. In terms of those on a PhD, they can switch after 24 months, but a significant change there that will impact a lot of your clients. Here we go again, then back to those EUSS changes. And I know Denai is on the webinar today, and Denai and I had a conversation, which is on my YouTube channel, where we discuss the impact of some of these changes. The first one was in relation to the deadline for the application deadline, and whether there's reasonable grounds for the delay in making the EUSS application. That used to be an eligibility requirement, but it's now from August been moved into it being a validity requirement. Therefore, if the Secretary of State doesn't think there's reasonable grounds for the delay, and their policy on what is reasonable grounds has been very much constricted, the application will be treated as invalid and you won't get a right of appeal. I've had to advise somebody in relation to this, and one way I found around it in this case was she'd made a number of applications where she'd been given a right of appeal, but had made new applications encouraged by the decision maker on her own without legal advice. When she did come to my solicitors, she'd been refused on a validity basis. What we did then is make a late appeal against one of the decisions where she did have a right of appeal, and put an explanation there that she didn't know she wouldn't have a right of appeal in the future, and she'd been encouraged to make a new application, and the tribunal granted an extension of time in that case. A positive development is the third bullet point on this screen, and this is the automatic extension of pre-settled status. Finally, the decision from 21st December 2022 of Mr. Justice Lane in the Independent Monitoring Authority case was implemented. And from September, we've seen the Home Office granting automatic extensions to pre-settled status. Now, still, if you have a client, or if you're eligible to get settled status, I'd encourage applications to be made. But now people shouldn't be left without status. There should be this automatic grant or extension for 2 years of pre-settled status. They have talked about in 2024 automating grants of settled status and doing checks against things like HMRC, which might cause problems for some clients. Another big EUSS development was from the 8th of August, the closure of new applications to the Surinder Singh route and also the Zambrano route. We know the Home Office never liked those routes, but they've closed it now to new applications, all right, from the 8th of August 2023. Remember earlier I said there was a mistake in Appendix Adult Dependent Relative. Well, that was corrected in this statement of changes. Originally, the ADR rules, when it was a couple applying, so a parent or a grandparent, only one of them had to show the care needs. Whereas when you read the new appendix adult dependent relative, it was written in a way that both had to show the care needs. Well, that's the old position has now been restored. When you have, say, grandparents in Pakistan, granddad has dementia, grandma can't look after him, she doesn't have to show care needs as well, only one of them does. Let's go to the second statement of changes from July. That was the change on the 19th of July. And all that did, a small change in HC 1715, and that was making Dominica, Honduras, Namibia, Timor-Leste, and Vanuatu visa national countries. Dominica and Vanuatu, they had this citizenship by investment scheme, which the Home Office think there's abuse of. So they've made them visa nationals. In terms of the other countries, the Home Office had found that people had been coming in as non-visa nationals and then claiming asylum from those countries. So from 3 p.m. on that day, they've made them visa national countries. Let's look at the highlights then from the autumn statement of changes, HC 1780 from the 7th of September. And they are implemented from various dates from the 28th of September onwards. The big change is in relation to the EUSS, so back to the European Settlement Scheme, and that is the removal of the right of administrative review. Previously, EUSS cases, most EUSS cases had a dual remedy, had both administrative review and a right of appeal. For all decisions made on or after the 5th of October 2023, there is only so whenever you made that application, doesn't matter, it's the date of decision that matters. On or after then, you will only get a right of appeal. Again, there's some developments to the youth mobility scheme. So now there's bilateral arrangements with Australia and Canada. So they get the enhanced youth mobility up to the age of 35 and the 2 to 3 years now for them. This was the statement of changes that also sorted out that mistake they made on the definition of lawful residence. So they've now made it clear. It says this: the rules are being changed to clarify that this exclusion extends to time spent on previous versions of immigration bail, brackets temporary admission or temporary release, and previous visitor, short-term student visa or seasonal worker routes. You also need to be aware that there's a new appendix children. It's a cross-cutting appendix. It doesn't introduce any new requirements, but be aware of it if you're applying under certain categories and make sure you comply with it. There was also a change to appendix travel authorization, and the NHS debt provision was removed from appendix electronic travel authorization, although you still can be refused entry because of an NHS debt. Again, we talked about changing your precedents. Now the returning resident rules are in appendix returning resident. So if you're making an application for a returning resident, you're no longer relying on part 1 and paragraphs 18 to 20 of the rules, you're relying on appendix returning resident. And again, if you as a firm or as a practitioner need help with developing representations and precedents, I know some of the consultants at DG Legal would be happy to help you with that, and do reach out to them. There was also an extension to the Gurkha concession. Have a look at that. And then finally, the December statement of changes. So the most recent statement of changes, HC 246 from the 7th of December. Implementation dates range from the 7th of December to the 31st of this month. Again, changes to the EU settlement scheme, changes to travel document requirement for school groups from France. Again, some enhancement for specific countries for youth mobility. So that's happened again throughout the year for different countries. And again, 3 new appendices. Bereaved partners now have their own appendix. Statelessness, own appendix. and victims of domestic violence. And for the first time, we've seen the introduction of an out-of-country route for victims of transnational marriage abandonment. There was a case which was successful in the admin court about somebody who was abandoned abroad, somebody is on a spouse visa who was a victim of domestic violence, and the rules have been amended in relation to that. What I've done in the slides is set out the Secretary of State's written statement. So first thing, there's the change to the visitor rules and the permitted business activities. Notice B there, naming remote work as a permitted activity, provided this is not the primary purpose of the visit. There's also reform to the permitted paid engagements. New appendix statelessness. Notice a partner and child can't apply as a dependent, and then they'll have to apply then under appendix FM. In terms of changes to the EUSS, in terms of applying as a joining family member, you can't apply if you're an irregular arrival to the United Kingdom. Also, if you arrive on a visit visa, you need to apply within 3 months as a joining family member. Changes to travel document requirements for school groups visiting from France. That does what it says on the tin. In terms of appendix domestic abuse, I've told you about that and the victims of transnational marriage abandonment. In terms of the extension to the youth mobility scheme, Uruguay is added, and then you've got the extension in relation to Japan and the Republic of Korea. What I've tried to do to help is set out bits from the explanatory memorandum, which gives you a bit more details, particularly to the appendix bereaved partner, appendix domestic abuse, and appendix statelessness. So if you're making applications under any of those, have a look at those new appendices. Wow, time to take a breath, take a drink. Those were the statement of changes to the immigration rules. So buckle up. We're now going for a high-speed roller coaster route around the case law of immigration for 2023. And let's start with a biggie, probably the biggest case of the year. And it's ironic that there's Parliament debating the Rwanda bill again this week. But in AAA Syria, the Supreme Court unanimously dismissed the Home Secretary's appeal, upheld the conclusion of the majority in the Court of Appeal that the Rwanda policy is unlawful, substantial grounds for believing a real risk that would face ill treatment due to refoulement. They did dismiss the cross appeal that was based on retained EU law, just to be aware of that. Now, this is probably the heaviest case of the whole session, so screw your brains on for this bit. This is the case of Afzal, and we're getting into the territory of long residence, disregarded periods of overstaying, the case of Hock, remember that, Section 3C and Rule 39E. I've done a separate video on this, which is about 15 minutes long, I think, so if you need more detail, have a look at that. Afzal had a gap in his leave because what he'd done, he applied for a fee waiver. That was refused, so he was given the 10 days to pay. He paid the application fee, but didn't pay the immigration health surcharge. His application was then rejected. Within 14 days of that rejected application, he made a new application, which was successful. Now, he actually won in the Court of Appeal on that point that his disregarded period could be covered because his new application was within 14 days of the rejected application. And Sir Patrick Elias interpreted 39E as including rejected applications, not just refused applications. And that point didn't go to the Supreme Court. And in fact, 39E has been amended to that effect. The argument was about his 3C leave and whether his application was in 14 days of his 3C leave expiring by virtue of 39E 2B2. Simply put, his 3C leave, it was valid while he made his application, And then while he was given the 10 days to pay the fee and the surcharge after his fee waiver was rejected, when he didn't pay that fee, his leave ceased. Therefore, his subsequent application was not within 14 days of the extension of his leave under 3C, so he could not rely on 39E2B2. In terms of disregarded periods of overstaying, what Lord Sales said is, he confirmed what the Court of Appeal said, that they act as a shield, not a sword. What does that mean? Well, you can't count the period of the disregarded period positively towards the 10 years. But what you don't lose out on is it doesn't sort of set the clock back to zero. You can rely on the period before the gap and the period after the gap and add them together, and the gap is disregarded. So that's the true meaning of disregarded periods of overstaying. Ayaki's case was different. He was trying to rely on a previous application. 276B refers to a previous application, and he'd made a previous application within 14 or 28 days, but it was unsuccessful. But he was trying to rely on that to then get a disregarded period of overstaying. The Supreme Court agreed with the Court of Appeal and said, where the rule refers to a previous application, it's referring to the application that was successful and led to leave to remain being granted. Now, once again, the Supreme Court, like a lot of the senior courts, said, look, Home Office, you need to sort this rule out and rewrite this rule and clarify it, because as you've just witnessed, really complicated stuff. And I'd encourage you to go back to my video on this. Solicitors, if you've got a case on this issue, feel free to reach out to me because it's heavy ground. Let's have a look at something positive. It's the case of Core. That's a case that's really useful in terms of Article 8 proportionality outside of the rules, and perhaps if you're challenging a refusal by the tribunal on Article 8 grounds. The focus of that appeal was actually an ETS TOEIC allegation, and I think as a result, the representatives didn't really focus on Article 8, and it is a real emphasis on how we need to make sure we evidence the human rights claim, because ultimately the appeals in these circumstances are human rights appeals. But the case eventually came before the upper tribunal, who found that Core had used deception and went on to dismiss her Article 8 claim. But the Article 8 assessment was very brief. It misinterpreted the circumstances because she was married to somebody who was now British, Harjinder Singh, and the judge treated him as if he was an Indian citizen, and there wasn't a proper weighing of all his circumstances and their circumstances. The fact it was a love marriage, they would face disapproval, there was IVF treatment ongoing, and they wanted a second course but couldn't do it. There were other health issues. He had a business. There was no evidence he had dual citizenship. All those things should have been weighed in the balance, and the tribunal should have conducted a proper balance, and they didn't. Again, I've done a longer video on this where I go through the paragraphs you might find helpful, but a really helpful case because the scenario I'm explaining is similar to a lot of our clients. NC is the latest case clarifying the very significant obstacles to integration test. That was in 276 ADE. It's now in Appendix Private Life. Again, when you're making your submissions, make sure you're making them under Appendix Private Life. I did a whole webinar for DG Legal. It's still on my YouTube about Appendix Private Life. I've also done a video about this case specifically. So if you're trying to argue very significant obstacles to integration, have a look at that. She was unsuccessful in her asylum case, but the judge found she had a genuine subjective fear in St. Kitts, and it ended up allowing her very significant obstacles to integration appeal on the basis that her subjective fear would stop her conducting a normal life. That was overturned by the upper tribunal, who said, well, look, the judge focused too much on the subjective elements. Lady Justice Whipple clarified the test. Look at the 3 Roman numerals. The decision maker must reach a broad evaluative judgment. That's with reference to the case of Kamara. I'm sure you're familiar with that. The judgment must focus on the obstacles to integration and their significance for the individual appellant. That's the case of Parveen. Parveen's a really helpful case because it disapproved of what was said in Trabawan. But look at 3. The test is not subjective in the sense of being limited to the appellant's own perception of the obstacles to reintegration, but extends to all aspects of the appellant's likely situation on return, including objective evidence, and requires consideration of any reasonable step that could be taken to avoid or mitigate the obstacles. So we really need to evidence our application on very significant obstacles to integration. Get country evidence. Get maybe a psychologist or a social work report. How would they be affected by going back? Would they be able to access a proper private life there and reintegrate? I'm conscious of time, so this roller coaster is going to go faster for the last 17 minutes. Abdi is a really interesting case. 3 Somali nationals, relatives of Ashkia, a Dutch national in the United Kingdom. Sole issue before the FTT was dependency. Really helpful quote there from Lord Justice Popperwell on the meaning of dependency. You want to lift that into your skeleton arguments and your representations. Look, it's not necessary to establish that the EEA family member is the sole source of funds from which the applicant meets essential living needs. The support must be material in the sense that without it, the applicant could not meet all their essential needs. And there's a really helpful quote there from the guidance, and the Home Office guidance still says similar things in the current iteration. The applicant does not need to be dependent on the EEA national to meet all or most of their essential needs. For example, an applicant is considered dependent if they receive a pension, which covers half of their needs, and money from their EEA national sponsor, which covers the other half. What happened, in short? Case comes before Judge Bartlett, no PO. Sole issue is dependency. Judge hears evidence, then dismisses it on dependency, finding that Ashkia was not even the source of funds to the appellants. That was never an issue that was raised by the Home Office, wasn't raised by the judge. Appeal on fairness grounds to the upper tribunal. The upper tribunal says, well, no procedural unfairness by the failure to raise the issue, and it wouldn't have made a material difference anyway. Case goes to the Court of Appeal. There's some sort of argument in the Court of Appeal, the Home Office trying to say, well, we don't know what happened before the FTT. And Lord Justice Popperwell, I think it is scathing about that, because he says, well, there was no dispute as to what happened in the first tier in the upper tribunal. And in any way, we've got counsel telling us what happened. And what he does, it helpfully summarizes the procedural fairness case law, and he says there's a wealth of authority on the circumstances in which a failure to raise a point at a hearing amounts to procedural unfairness, and he has little hesitation in finding that the judge had acted unfairly. And he disagrees with the Home Office that this was an obvious point that needed addressing, and he says, to put it at its lowest, considerable doubt whether as a matter of law the source of the money is of any relevance to the question of dependency. So a helpful quote there you might want to rely on. I'm sure practitioners have come across an increase in the number of deprivation decisions. In the recent annual report from the senior president of tribunals, the president of the upper tribunal notes that they've had to grapple a lot with the question of how to decide post the decision in Shamima Begum, deprivation of citizenship appeals. Now, they're often under section 43 of the BNA. That's where you obtain naturalization by or registration by fraud or non-disclosure. Obviously, Begum was under 42, which is conducive to the public good. A case, Chimmy reported case, Emma Rutherford from my chambers was involved in that case. This sets out the steps that the tribunal should have to take. So this is in your representations, your skeleton. This is the steps you want to take through. Did the Secretary of State materially err in law when she decided the condition precedent in 42 or 43? So was there an error of law when she decided that you're not conducive to the public good or you obtained your naturalization by fraud? If there was an error of law, the appeal should be allowed. If not, did the Secretary of State err when she exercised her discretion to deprive? If yes, the appeal falls to be allowed. If not, then there's the human rights assessment, and that's for the tribunal to assess themselves. Because question A and B, that's a public law assessment, like a JR, because that's following the principles from Shamima Begum. When it comes to Article 8, it's for the tribunal to decide for itself. Paragraphs 2 and 3 deal with evidence. When answering questions, the first 2 questions about the condition precedent and discretion, they look at the evidence that was before the Secretary of State or evidence that's otherwise relevant to establishing an error of law. In terms of human rights, they've got a wider consideration of evidence. In a recent case called Collicage that was successful, And the appeal, it reiterates the point that if the Secretary of State fails to exercise her discretion or makes an error in her discretion, the appeal should be allowed. There's also questions in here about procedural fairness and whether the Secretary of State should notify that she's minded to deprive. It was a she at that time. In July, the Court of Appeal wrestled with these questions in the unfortunately named case Shaiti. In this case, ultimately, Lady Justice Elizabeth Lang didn't make a decision on the argument that a different approach should be taken in deprivation cases on fraud 43 basis to the conducive basis. So the argument is that the tribunal should have a full merits appeal. Now, she saw the force in the argument, but didn't need to decide it as that appeal failed on another ground. So I still think we'll see this issue going through the courts. This case of TC was a case of mine. I'm not going to talk about it for long, but it's important in terms of the new tribunal procedure and the way the tribunal is going to focus on the issues and make issue-based determinations, which are going to be shorter. So don't forget to do a proper skeleton argument. Remember the 3 S's, a summary, the factual summary, and the most important bit, the schedule. What are the issues the tribunal are going to have to decide, and set in there what the Secretary of State concedes. And then your 3rd S, make your submissions. And that'll be the focus. And then there should be a proper review from the respondent and a written review that engages with that. There's a helpful appendix at the end of TC about principles for granting permission to appeal when you challenge a decision. So if you're drafting grounds to challenge a decision of a judge, have a look at the appendix to TC. The other thing I'd say is if you're arguing a case on medical treatment grounds, look at this case, because it's not in the head note, but we won on Article 3 medical grounds in a deportation case where it was a mental health issue going back to Zimbabwe. And it's a good example of a successful medical case, but it's not in the head note. So have a look at that. When you're in the upper tribunal, you'll need to make submissions if an error of law is found on whether the case is remitted or retained. The presumption, and Begum says this following from AEB, is that it will be retained in the upper tribunal unless the exceptions are applied. What are the exceptions? Where there's been unfairness or there needs to be extensive fact-finding. And in the Court of Appeal in AEB, the upper tribunal will criticise for holding on to a case where there had been unfairness. But in this case of Begum, they do clarify that not every case where there's been unfairness will it be remitted back. So make sure you're prepared to address the upper tribunal on whether it should be retained or remitted, and address paragraph 7.2a and b of the practice statement. Just a quickie, the tribunal can't dispose of an appeal without considering the merits. The Secretary of State had failed and failed and failed in this case to comply with directions. So the tribunal took it that she didn't oppose the appeal and allowed it outright in an asylum case. The upper tribunal said you can't do that. There's also some helpful guidance in this case of when cases can be disposed of without a hearing on the papers. So have a look at that. And whenever credibility is at issue, it shouldn't be. Giving evidence from abroad. Raz is an interesting case. He'd been, I think, removed to Pakistan prior to his appeal, but he gave evidence by video link without the authority of the Pakistani authorities. They lost. And then they appealed to the Court of Appeal saying, well, hang about, it must be a nullity then, because if we didn't have permission for our client to give evidence, it's a nullity. The Court of Appeal unsurprisingly rejected that argument and said it's a diplomatic issue, but it doesn't make the proceedings a nullity. If you want somebody to give evidence from abroad, follow the Presidential Guidance Note number 4 of 2022. Also, I've put in a new link for some guidance on giving evidence from abroad, and it sets out the different countries and the requirements. Helpful to have a look at that. One of the big headlines of the year was the Chelik case. This was durable partners. These were the ones who didn't have a residence documentation under the EEA regulations and didn't get married till after the end of the transition period, often because of COVID, and they couldn't get married. Their appeal was rejected, and Lord Justice Lewis found they weren't covered by the withdrawal agreement. He has left the door open, mind, because he didn't decide all of the arguments of the interveners. And one of the interveners' arguments were that their EUSS application should have been treated as an application under the EA regulations. And what he's done, he's given permission in a reported case called Sadiqa, which we'll come to in a minute. And that's going to be heard, I think, in next month, in February, about the argument about whether the EUSS application should have been treated by the Secretary of State as an application under the regulations. Here's the slide for Sadiqa. In Sadiqa, the Upper Tribunal distinguished some unreported cases, relied on Batul, and said the Secretary of State was not obliged to treat it as an application under the EA regulations when they'd wrongly selected the EUSS. We'll see what happens in the Court of Appeal. A recent case called Danny from November pretty much rules out, I think say probably in deportation cases, in EUSS refusals, the ability to argue human rights, because effectively it's a refusal of leave under the EUSS. There's no requirement to leave the UK, so it's not a refusal of a human rights claim. So you're not going to be able to raise human rights in EUSS cases. Alaraj was an unfortunate case. He was admitted as a durable partner. The IO put a stamp in his passport and said he was admitted under the EA regulations. When he applied under the settlement scheme, his appeal was allowed by the first tier tribunal. Secretary of State appealed to the upper tribunal, who had sympathy. He'd acted in good faith, and they were aware of similar stamps being put in people's passports. But effectively, that was not a relevant document for the purpose of the EUSS. There was no power on the immigration officer to do what he did, because family permits could be granted by entry clearance officers, registration certificates and residence cards by the Secretary of State, and those were the relevant documents into the EUSS and not this stamp in the passport. So unfortunately, his appeal was dismissed. Sonkor reiterates what was said in Akinsanya. If you've got leave under another part of the immigration rules, you are not a person with a Zambrano right to reside. I've recently done an appeal, and I think I got the decision yesterday, and we were successful, where the Home Office were cheekily trying to extend this and say, oh, you had the potential to apply under Appendix FM. At the time, my client had a Zambrano residence card, and they were relying on velage. We won the appeal. If you've got that sort of argument, get in touch with me. Certainly, if you've got leave under another part of the rules at the relevant time, you're not going to succeed following Sonkor. Osune is about Zambrano rights of appeal under the EA regulations. If you've got a Zambrano case, have a look at that. Because of time, I'm not going to go through that. Rexage is about when you can continue to rely in EUSS cases on assumed dependency, where a dependent parent was successful under their family permit application on a basis of assumed dependency, and the upper tribunal found they could continue to rely on that assumed dependency in their EUSS application in the UK. I've put the extract from the slides. This is a great case reported in 2023, but it's from 2022. It's a case from Upper Tribunal Judge Bruce in relation to Surinder Singh Kutbuddin. They were trying to argue, the Secretary of State, that you had to show you were lawfully resident. The extended family member of the British citizen was lawfully resident, say, in Ireland. Upper Tribunal Judge Bruce rejected that. And there's this quote at paragraph 45 where she relies heavily on ZA. I love this quote. I rely on it in all my Surinder Singh cases. Because of time, I'm not going to read it out to you, but do have a look at that. One of the themes of 2023, on 3 occasions, the Court of Appeal had to remind the Upper Tribunal as to the correct approach to the standard of proof and the lack of requirement of corroboration in protection claims, and how credibility is to be assessed and how people will struggle to get evidence of being monitored in the UK. Really helpful decisions. I'm just going to give you the headlines. WAS Pakistan, that was an NQM case about being observed in the United Kingdom, their political activities in the UK. ASO Iraq was an Iraqi case, risk because of his relationship with his girlfriend. Again, helpful stuff on the standard of proof and credibility, and reminds the Upper Tribunal, before finding an error of law is immaterial, they have to properly identify what the errors are. So generally helpful in terms of the Upper Tribunal there. And then MAH Egypt, Lord Justice Singh allows a case outright where the Secretary of State, the Upper Tribunal only rejected it from the lack of corroboration. Some really helpful stuff on credibility and corroboration there. And I've given details in the slides. 3 minutes left. Let's see what we can do. Ahmed deals with historical injustice. If your client has been a victim of historical injustice, so the wrongful operation of by the Secretary of State of her immigration functions, if they can show they've suffered as a result of that historical injustice, that might be relevant to the Article 8. They'll look about what your client did about it. Remember, historical injustice is different to historic injustice, like what happened to the Gurkhas, but that might be relevant to Article 8. In terms of Chikwamba has been narrowed down, so your ability to satisfy the entry clearance requirements, I think it's still relevant generally to proportionality, so you can have a big impact with the only basis is that you could go back and apply for entry clearance. But in most of our partner cases, under the 10-year route, they'll be refused because there's no insurmountable obstacles to the couple living there. But have a look at that in relation to Chikwamba. Some final closing thoughts then. There's a recent case on the no recourse to public funds policy where they didn't consider their discretion. They just said, well, you're not an application on the family or private life route or outside the rules. There's been a policy now where they will consider their discretion. So if you've got a change of circumstances application, have a look at that. If they're minded to refuse because of dishonesty at the border, this was somebody where they thought their English language was dodgy. They didn't follow the minded to refuse procedure from Balajagari. That decision was found to be unlawful in Tazim. A Windrush case that was an abusive process where they'd signed a disclaimer accepting a sum in full, then sought a JR later. The destitute domestic violence concession doesn't apply wider to a tier 2 dependent, that's SWP. If you're challenging a naturalization case, you do it by irrationality grounds, not proportionality. It's difficult to challenge a refusal of naturalization on good character. This was Mr. Justice Mostyn getting very colourful just before he retired. But remember, it's an irrationality challenge. If you're looking to challenge an unduly harsh refusal in a deportation case, the Shwebu case, judge was criticised for being inappropriately criticising an expert witness in that case, so worth a look at. This is the biometrics case where the policy was found unlawful and led to the new biometrics policy. I've done a video on that where you can ask to be excused from your biometrics or have them predetermined in an entry clearance case. Rohig was led to the British Nationality Regulation of Past Practice Act. These were the EU nationals who'd been here between 1st January 83 and 1st October 2000 exercising treaty rights, and they were considered settled, so their children was British. Rohig came to the opposite conclusion, but then the Secretary of State rectified that. Great work by the Project for Registration of Children as British Citizens, but they led to the British Nationality Registration of Past Practice Act 2023. This is the case on an unlawful Home Office policy where somebody was detained unlawfully at the border where they had leave. They were asked about their NHS debt and the Secretary of State had a secret policy and Mr. Justice Chamberlain found it unlawful. That wraps it up. It's 2 o'clock on the dot. I'm sorry I had to go fast at the end. There's the QR code to scan. Connect with me on LinkedIn and YouTube, on Twitter. There's the Telegram link. You'll get the resources from this webinar and the video. I'll try and also post the video on my YouTube channel. Back to Aaron just for some closing thoughts. Thanks everyone, and thanks DG. Really pleasure to be with you today.
Thank you, Adam, for that. That was great. We, as Adam said, don't have time for questions today, but of course the slides and a recording of the webinar will be sent over to you tomorrow. This afternoon, you should receive an email asking to rate the webinar out of 5 stars. If you have enjoyed today, then please do leave feedback. Please do give us that 5-star rating. And as well, you can give us suggestions for future webinar topics. And on that note, our series of webinars will continue on Tuesday, the 13th of February. And that webinar will be on stress less, work more. and that will be presented by Amanda Marquis Wright Robinson of Russell Street Chambers and the Barrister Group. So I'd like to say one more time, thank you again to Adam for presenting that webinar, and we wish everyone a good afternoon. Thank you very much for watching.
Thanks, everyone.